Hello everybody. Today it will be our 33rd lecture series, and I have already mentioned in my Facebook that the lecture series will be on the recent matter which is happening at the Supreme Court of India, and which is also with the Chief Justice of India of the Supreme Court regarding the WhatsApp matter. We all know that there is a issue of privacy which actually revolves around this case which has been taken up in Supreme Court, and this is a very serious matter also. There are many intricacies which are involved, but I will not go into the legal intricacies of this matter. I will give you we will discuss about that what happened, that the WhatsApp has been penalized for a particular kind of an event, and after this how the Supreme Court takes up the matter and gives us a very important and the CJI, the Chief Justice of Honorable Chief Justice of India, has given a statement that you cannot play with the privacy of the Indians. So this is a very important statement which has been given by the Chief Justice of India, Honorable Chief Justice of India, Supreme Court of India. So it actually, why it happened and what are the matters which are actually involved in it. We will have a little bit of understanding, and we will continue with the series later on. But I will end up with only the facts and the circumstances which came before the Supreme Court of India and what actually revolves around, which are available in the media as well as in the print media and electronic media, and the information that we get from them. What happened is the Supreme Court of India slammed WhatsApp, the parent. Obviously we all know Meta, we use in Facebook the Meta platforms, while hearing a plea regarding the WhatsApp 2021 privacy policy. Now the policy allows the WhatsApp to share the users data with the Facebook and all its group companies for the purposes of the commercial advertising and marketing. We all know it is a kind of a platform, and it is used by the WhatsApp and the Facebook to advertise the products and all the marketing companies. It's a digital platform. So obviously the court made the observations while hearing the appeals against the Competition Commission of India, CCI. I will talk about this institution, the Competition Commission of India. It's a regulatory body, and the Competition Act 2002 it has been established to look after the competition matter in India. Imposing a penalty of rupees, CCI, Competition Commission of India, imposed a penalty of rupees 213.14 crore over the privacy policy. Now, appearing for the government, the Solicitor General Tushar Mehta criticized the exploitative policy for sharing the users' data for commercial purpose, and Chief Justice responded, "If you can't follow our constitution, quote unquote, if you can't follow our constitution, then leave India. We won't allow citizens' privacy to be compromised," quote unquote. The CJI commented on this matter. Now, calling the practice a mockery of constitutionalism, the court questioned how consent can be considered valid while the users are effectively forced to accept a policy on a take it or leave it basis. Honorable Justice Joymallo Bagchi also observed that what has been held against the companies that the consent obtained was manufactured consent. The Chief Justice of India observed that where there is a question to opt out, show me in your mobile, that I will show in your mobile, this is a decent way of committing theft of private information. So he underscored the WhatsApp market dominance. Obviously, the dominance is coming into the picture because the matter is with the Competition Commission of India, CCI, which actually, and the dominance falls under the area of the Competition Act 2002, saying that you know your commercial interest and you also know how you made consumers addicted to the app. If for everybody uses it, consumers has no choice that you have created a monopoly. So the monopoly also comes up, the market dominance also comes up. So a bench led by the Chief Justice of India, Suryakant, while hearing the appeals which has been filed by the WhatsApp and the Meta, as well as a separate appeal by the CCI challenging on one of the NCLAT findings, said that we will not allow to share a single piece of information and you can't play with the right to privacy in this country, emphasizing that the right to privacy cannot be compromised, and the bench asserted that it would not allow the rights of any citizen to be violated. Now, this is a decent way of committing the theft on the privacy of the country. Right to privacy is so jealously protected in this country, we will not allow you to violate it. Now, Senior Counsel Mukul Rohtagi, appearing for the Meta and the WhatsApp, submitted that a related matter is pending before the constitutional bench, and the service is free of charge. No consumer asked to pay. Senior counsel also said that Arun Kantapalia clarified that all the data is shared, only specific data. Now the court here posted the matter for the purpose of issuing interim directions on the February 9th. The bench asked the WhatsApp and the Meta to file an affidavit for giving a categorical undertaking that they will not share the user data. The court also indicated that if any such kind of an affidavit is not being filed, their appeals against the NCLT order are liable to be dismissed. What exactly is the WhatsApp 2021 privacy policy is? Now, the new policy says that apart from the Facebook, the family of the companies, the WhatsApp receives the information from and shares information with the family of the companies. We may use the information we receive from them, and they may use the information we share with them to help operate, provide and improve, understand, customize and support and market our services and the offerings. So under the WhatsApp Privacy Policy 2021, WhatsApp users have two options: agree to share their personal information with the Facebook or delete in their WhatsApp account. Since releasing the initial policy change, WhatsApp later clarified that the company does not collect data from the messages sent between the family members and friends, just from the personal information what the users send businesses. Information that users send to the business can be collected and shared with the Facebook for advertising. So obviously there is a linkage of quite a big linkage of revenue generation from the Facebook and the Meta. Obviously the matter is with the highest court of the country, the Supreme Court of India. It is also sub judice. So we will not talk about the opinion of the the judgment or the interim kind of an order which has been observed by the Supreme Court, because it is actually under the judgment. But obviously we will look that in the broader aspect, like the privacy matter actually which is being taken up by the Supreme Court for the protection of the privacy of the citizens of this country. Now WhatsApp and the Meta platform incorporation, which is based in USA, along with the Facebook, has also got a kind of a social responsibility task. They will also not think anything otherwise than providing any information which will be detrimental for the general users of this country. So I think that it will be an amicable situation. The court will also understand that we need such kind of platforms also at the end of the day. So let the Supreme Court of the India, the Apex Court, decide on this matter. We will look forward for the judgment, and we will happily understand whether in the form of a legal context or whether from the general context, that what comes out of from this. So we will wait for the judgment to come up. Thank you very much for watching. You must have your own comments on this. Please give your valuable comments on this issue. Thank you very much for joining.